Well, this is a video that's awkward for me to make because I'm actually in the middle of making my mind up on something. And so I thought I would share what I already know, just in case anybody's following in the same footsteps I am in terms of being a little bit off the path, so to speak, in terms of our understanding on things in the Constitution. Now, you might start spotting a pattern in my videos where I like the idea of there being core philosophies, where essentially it's like a piece of computer code or a question that whatever you throw up against it provides you a predictable response. And always there's going to be some exceptions, but as long as the exceptions make sense, because not everything will fit directly into it. But you don't want exceptions just for the sake of making things happen your way rather than happening in a predictable way. So obviously a couple of my core philosophies follow along the non-aggression principle, the golden rule. And so I thought I was a constitutional originalist. Apparently, there's more than one school of thought in constitutional originalism, which was an eye-opener for me. So I was watching one of the episodes of Tom Woods, and he had a couple of speakers on from the 10th Amendment Center, and sorry, I don't remember their names off the top of my head. And they were talking about the recent Supreme Court decisions. Initially, they started talking about the Dobson decision overturning Roe versus Wade, and they're very much originalists, and they had nothing but good things to say about how this was interpreted, saying that the original Roe v. Wade decision was a living constitution interpretation of things, and therefore didn't have solid grounding in any particular form of philosophy, and that the Constitution is silent on it, and for the most part the laws of the United States were against abortion at some level. You'll hear some people say, oh, there were no abortion laws, and well, that's not true. There were various laws that involved like the quickening and other things that were understandable in the bounds of how they understood science at the time. So in terms of an originalist decision, if the Constitution says nothing, it means the government has no power. So then you look at the prevailing mindset of the people at the time and say, well, the Supreme Court shouldn't be imposing this at the federal level. This should be something the states would handle, as the states would have handled it back then. So a good originalist decision. Of course, the thing that caught me kind of slack-jawed is they weren't happy with the recent Second Amendment decision. They brought up a term I'd only vaguely heard before but never heard properly defined, and that was the idea of incorporation. And if you're very familiar with the 14th Amendment, you may already know incorporation well. I understood the idea of the Bill of Rights being applied via the 14th Amendment, but I hadn't heard it in terms of incorporation. Well, those all go together. So in their mindset, these guests on the Tom Woods show, as originalists, were not happy with the Second Amendment decision because, as far as they're concerned, the Second Amendment only prohibits Congress or the federal government from making interpretations on the rights described in the Second Amendment. And that in originalist doctrine, it would have been up to the states to handle things. So, and obviously that flies a little bit in the face of my ideas of how I believe individual rights work. I'm not going to change my opinion on individual rights, most likely. So I have to find a way of trying to figure out how to reconcile this. So let me give you a lesson as I basically, the Tom Woods guests provided their information in a very broad brush and high altitude version of things. So if you didn't understand the at the ground and through the weeds level of things, you at least walked away from it going, wow, what just happened? Which was my reaction. Okay, so, and this part I pretty much already knew. The Bill of Rights initially bound only Congress and the federal government, not the states. The Bill of Rights, if you might recall, I talked about in other videos, initially the Federalists did not want the Bill of Rights, and they only attached it later to essentially prevent a convention of states from forming to force it upon them. And there's a little known preamble that comes with the Bill of Rights, and the language is not, I mean, it doesn't slap you over the head, but it definitely sounds, the leaning of it says that this is aimed at the federal government and not the states. Okay, so between the founding of the Republic and the 14th Amendment, there were several Supreme Court decisions that upheld the idea that the Bill of Rights did not bind the states, only the federal government. I'll quote one from John Marshall, and it's pretty. John Marshall was very much a nationalist, ultra-federalist. He was very much in favor of consolidation of central power. In fact, it was his decisions that made the Supreme Court as powerful as it is. And on one of the findings dealing with the Fifth Amendment, he says, and I quote, if these propositions be correct, the Fifth Amendment must be understood as restraining the power of the general government, not as applicable to the states. In their several constitutions, they have imposed such restrictions on their respective governments as their own wisdom suggested, such as they deemed most proper for themselves. It is a subject on which they judge exclusively, and which others infer no further. In which others interfere no further than they are supposed to have a common interest. So essentially, what he's saying is the only time the Supreme Court can get involved in something that sounds like the Bill of Rights is if a state constitution has a similar Bill of Rights, but they are ignoring their own Bill of Rights. So that's the only time they can really intervene in individual rights in that type of situation. So, what is incorporation? Well, incorporation is the doctrine of enforcing the Bill of Rights upon the states. So, we know that before the 14th Amendment, incorporation didn't exist. So what happens with the 14th Amendment? Well, in general, we know the 14th Amendment was to essentially tidy up citizenship issues following the Civil War. The idea was former slaves were to be made whole citizens and essentially be treated by the law as equally as any of their other citizen counterparts. So one of the key phrases of the 14th Amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Now, some people say, well, yeah, that part of those privileges and immunities are the Bill of Rights. Unfortunately, if you look at the congressional testimony, because this was a amendment that was drafted in Congress, drafted by the Judiciary Committee, and all the things they say expressly disavow incorporation. And they note that the goal of the 14th Amendment is to constitutionalize the Civil Rights Act of 1866. They rightly noted that the Civil Rights Act of 1866 was not necessarily constitutional and therefore could theoretically be struck down by the Supreme Court. So they made it part of the Constitution so it couldn't be. And the idea was to codify that race wasn't a barrier to citizenship and all the things that came with being a citizen. Several Supreme Court decisions following the 14th Amendment restated against incorporation, most famously the slaughterhouse decision. So essentially the idea of incorporation started creeping in at a later date. The Supreme Court, for the most part, adopted what was known as partial incorporation. There are numerous cases involving the various amendments, and essentially most of the amendments were incorporated one clause at a time. So essentially between the commas, so to speak. The first case the Supreme Court interpreted incorporation in occurred in 1897. And it was a protection against taking property without due compensation. So that was a partial incorporation of the Fifth Amendment. We got a handful of First Amendment cases that occurred in the 20s and 30s, and the majority of the rest of the incorporation cases occurred during the 1960s. So at this time, the First, Second, Fourth, and Eighth Amendments are fully incorporated, meaning every bit of it is empowered against states. States are not allowed to violate those. The Fifth and Sixth Amendments are partially incorporated. The Third, Seventh, Ninth, and Tenth are not at all incorporated. So what the originalists will tell you, or at least this particular originalist school, their fear is that by using incorporation, even on something that's beneficial like the Second Amendment, it gives the Supreme Court power in the future to incorporate rights that may not, rights that we wouldn't recognize as rights. For example, they could take a right which is not enumerated, and it could be the modern interpretation of right, and they'll say, well, yeah, we see a right to this in the Constitution, and now we're incorporating it. That's the fear of this particular school of originalism. One example they like to give is they said originalists, comparing originalists to the living Constitution crowd. The living Constitution crowd, following the 14th Amendment, upheld segregation because overwhelmingly it was popular. So therefore they wouldn't interfere with it. Living constitutionalists kind of put their finger to the wind to see what the polls are saying, and that's how they interpret whether something gets passed or not. Originalists state that they believe that segregation was wrong immediately upon the passage of the 14th Amendment, because the 14th Amendment essentially puts a gag order on government in regards to race, meaning they no longer have anything to say about it. In a good way, because that's essentially the term gag order in terms of government is always meant to be a positive, whereas government has no authority to meddle in these areas anymore. So that's where I'm at on this at the moment. Definitely understand where they're coming from. It's not like I completely just blow it off and say it's wrong, but I can't believe that Justice Thomas just did what he felt he wanted to do. There may be something known, and I heard it hinted at, but I haven't found a good description of it yet. One of the big problems when you're doing research on this stuff is there's a lot of garbage out there that doesn't really give you decent information. It's people giving you their opinions and their opinions entirety, not backed up by anything that actually happened in history. So there does seem to be an originalist view where there's a narrow interpretation of incorporation. Specifically, incorporation only applies to the Bill of Rights and nothing else. How they construct that argument, I don't know. So, yeah, I'll probably talk a little bit about the Dobson decision in another video, but I just wanted to get this one out because it's rattling around in my brain, and sometimes talking these things out and writing it out makes it a little bit more clear. And yeah, I think I have this locked in my head very well. I just don't know if I'm ready to fall on the side of this particular school of originalism. I want to see their arguments on the danger side of things first before I fully commit to what they have to say. So I hope that was enlightening, and we'll definitely talk more about this later. Thank you very much for your time.